Well, the media is either lying about Sidney Powell and her representation in court, or they're admitting that they don't understand how defamation defense actually works. One of those two is true. Actually, maybe both of them. We'll figure it out. Hey, I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer, but I'm also a legal and political commentator here on YouTube. If you like that type of content, hit the subscribe button, hit that notification bell, don't miss any videos. Okay, so this story, you've probably seen it around, and what you've probably seen is a media misrepresentation of what's going on. So I'm here to clear a couple of these things up, but for the sake of YouTube, this video is not expressing an opinion or advancing an opinion about claims made by Sidney Powell in relation to the 2020 November election. This video is 100% neutral on those claims, and we are merely looking at the lawsuit brought by Dominion Voting Systems against Sidney Powell and the relevant legal questions involved. You in the audience are free to make up your own mind about the 2020 election. You cannot take my words or any words that may be quoted from this lawsuit or in this article as any sort of evidence or statement for or against anything. Okay, YouTube, I'll blink twice so everybody knows that I'm okay. If I blink more than twice, I'm not, and please put the guns down. Okay, that being said, Powell tells court no reasonable person would take fraud claims as fact. This was the headline. This is part of Sidney Powell's defense. And what comes after that from all of these publications is really an absolute travesty of legal interpretation. It's either intentional or so wantonly bad that it's disgraceful, but you know, it just is. It's just a misrepresentation of what's going on. So the background. Sidney Powell made a lot of claims about the 2020 presidential election as it relates to votes and Dominion voting machines. Dominion took umbrage with Sidney Powell's claims, calling them defamatory, and has sued her for $1.3 billion. Importantly, to the legal defense that Sidney Powell is pursuing in this defamation case, Sidney Powell not only made these claims in public, she also made them in court documents. She brought them in, I believe, cases in 4 different federal courts of her own volition, and she may have participated in some other lawsuits as well. But the claims that she was making in public mirrored the claims that she was making in these court filings, and that's a crucial distinction in this case. Okay? So, she made claims about Dominion's participation in the election and what that meant for how the election turned out. And then Dominion said that those claims were defamatory and have, again, like I said, sued her for $1.3 billion. Now, this is her first response to that lawsuit, and it is a motion to dismiss. It is a motion to dismiss for failure to state a claim, among some other reasons, but that's what we're focusing on. In federal court, if you are sued, a very, very common sort of almost a pro forma, a defense that is almost automatic is to file what's called a 12B6 motion to dismiss. That's where you state that the other party has not made a claim in their complaint that can be legally redressed by the court for whatever reason. Either they didn't provide enough detail, they didn't have enough facts, the facts, even if taken as true, wouldn't amount to any sort of civil injury that they could recover for, or the court is not able to grant the relief that they're requesting. So in this case, what Sidney Powell is saying is that they're not actually alleging what is legally considered to be defamation. And this is the trick. Let's take a look at this article. I'll have a link to the article down below. We're going to take a look at it. But if you want to follow up on it, it'll be in the description. It's from CBS News here. So lawyers for conservative attorney Sidney Powell told a federal court on Monday that no reasonable person would conclude her unfounded claims of voter fraud in the 2020 presidential election were statements of fact, as she fights the defamation lawsuit from Dominion. Okay. In a filing with the federal district court, Powell argued Dominion's case against her should be dismissed as it was clear to reasonable persons her statements were her own opinions and legal theories. Members of the public, she said, were free to reach their own conclusions. Determining whether a statement is protected involves a two-step inquiry. Is the statement one which can be proved true or false? And would reasonable people conclude that the statement is one of fact in light of its phrasing, context, and the circumstances surrounding its publication? Her lawyers told the court. This is correct. So first you have to show that the statement is a statement of fact, or is, let me rephrase that, because be more precise, is capable of being a statement of fact. Because just because something is capable of being a statement of fact doesn't mean it's given as a statement of fact. There are all sorts of things that are capable of being factual, but can be said in a comedic sense, a parody sense. They could be sarcastic, all sorts of things. Like I could say, oh, Governor Whitmer is a great governor, for example, right? Like that would be a sarcastic statement. Not getting too far into that. So anyway, you have to first determine if a statement is capable of being factual. That is, can someone figure out whether it was true or false if they had all possible information? So this is an objective standard. So it's not just, can I determine if it's factual, but can it be determined if it was factual? So things that happen behind closed doors and only one or two people know about those things, even if I may not be able to access those facts, if I had them, would I be able to know if they were if it was a fact or not, if it was a true or false statement, if I had all of the available information? The second part of that is, would a reasonable person conclude from the statement that the statement is one of fact in light of its phrasing, context, and circumstances? All three of those. So I mentioned earlier, like a sarcastic statement, you can pick up from the phrasing. The context of a factual statement really, really matters, and the circumstances surrounding its publication is similar to the context. And in this case, what the argument is that Sidney Powell made these statements in the context of filing lawsuits that relate to matters of public concern. So she is talking about political speech. She's making political speech about the voting process and Dominion's participation in it. It's a big public concern because it's about the election of the president of the United States. And she's doing this speech in the context of filing federal lawsuits that say the same things. And that's where she's hanging her hat on this defense. She's saying, look, I'm bringing these claims in court. I'm providing the information to the public about the claims I'm bringing in court. She's not saying something different outside of court than she is inside of court. She's making these claims. She's putting those claims up to the court to be tested. And the argument is that when lawyers bring something to court, there are two sides to the story, at least, right? There's the plaintiff's side and there's the defendant's side. And then there could be other sides that want to chime in as well, but at least those two sides. And those sides aren't to be taken necessarily as correct because someone's going to lose that lawsuit. And if you think about how ridiculous it would be if everybody who lost a lawsuit got sued over everything that they said in the lawsuit, that would be a messy system. It would be impossible to carry on any sort of legal action against anybody because some court is going to find some facts to be more true or more relevant than other facts. Every single time that a lawsuit is actually brought through the fact-finding process, the court's job is to find out which facts are true. And oftentimes, someone's going to say something that's not true. And we know that not everybody who says something that is not true or correct in court is put in jail for perjury. And in the same way, they're not sued for defamation. There's actually a privilege around this called litigation privilege, which allows you to make those sorts of statements and to make these sort of claims without being sued for what you say. But that litigation privilege has limits. And this is the hard part for Sidney Powell. Now, let me be frank with you about this. I don't think Sidney Powell's going to get this lawsuit dismissed against Dominion at this point in time. She's made her argument. It's a lot bigger than the media has made it out to be. It's a 90-page memorandum. It's not just, none of it was facts, bro, like they're portraying it. It's actually a very robust legal defense. I don't think it's going to get dismissed. It certainly could, but I don't think that's going to happen in this case. But I want to point out that it's there, and I want to be frank with you about my opinions of how it's going to go. That being said, here's one of the reasons that I don't think it's going to be dismissed. The litigation privilege has limits, and those limits matter a lot. And what those limits say in some contexts are that, sure, you can bring your lawsuit. You can bring that lawsuit and say what you need to say in that lawsuit without fear of repercussions from the other party suing you for what's in the lawsuit. However, if you are the one to publicize the lawsuit, if you are filing that lawsuit for the purpose of making those statements and then attempting to use that lawsuit as a litigation shield, as some sort of privilege, that makes you lose the privilege. The privilege exists to protect your actions at law, not your actions in public. So now if I were to make statements in a complaint against someone and that person determined they were defamatory and it was filed in a lawsuit and I just make my statements and was quiet, that's fine. If I make those statements and then I go to hold a press conference, for example, and say, let me tell you about all the reasons that Joe is a terrible person, they're right here in this lawsuit that I filed. Like, let's remember that I filed this lawsuit. They're right here. What privilege am I doing? I'm not engaging the court at that point. I'm engaging the public. And this is where Sidney Powell's defense has real potential problems, because Sidney Powell did call press conferences about this. She did actually release her complaint prior to it being filed, I believe, or at least prior to it being publicly available through the court system. It was publicly posted on her webpage. In fact, I believe it was publicly posted. People mentioned some errors that were in there, and those errors were even corrected before it was filed. I may be wrong on that, but that's what I seem to remember happening in at least one of the cases, maybe the one in Michigan. But that being said, those actions by Sidney Powell, calling press conferences, releasing the complaint to the general public prior to filing, or at least prior to it being publicly available, those may actually have destroyed the litigation privilege she would hold in this particular case. Now, that will be up to a court to determine if that's the reasoning, or if they just say, you're still not privileged in this way. There's all sorts of ways the court can go. That's one of the big problems that I see with her claim, is that she did make these things public in her statements both before and after filing. And while it's true that those would have otherwise come out, she is the one who directed their release at the onset of it. And that could destroy any litigation privilege that she may be arguing. But let's see what else her lawyers say here. She says, analyzed under these factors, and even assuming arguendo that each of the statements alleged in the complaint could be proved true or false, no reasonable person would conclude that the statements were truly statements of fact. Powell further argued her statements are constitutionally protected. Now, this is a different argument, and this is potentially a good one, in part because they were made in context of a bitter political debate, and the political statements are prone to exaggeration and hyperbole. And we've seen this before, actually, in the case where Stormy Daniels sued Donald Trump over her speech. The judge said Stormy Daniels entered the political arena, and that political speech was entitled to the maximum protection. Now, this is not directly analogous here. However, Dominion does have to consider the fact that they participated in an election, and not just an election. They participated massively in the presidential election in the United States. There is going to be discussion about it. There are going to be people who make claims about what happened in that election, and they're subject to those claims. The question is, do the people making those claims, are they making them with actual malice? Are they knowingly making false statements? Or should they have known to the point where they were being reckless and disregarding the ability to find out the truth? Sidney Powell's defense here is going to be something along the lines of, well, how can I find out the truth? Dominion's, voting methodology is a proprietary system, and they won't let us or the courts have access to it. These are the types of things that are probably going to have to be argued in court, as I don't think this motion to dismiss is going to survive. But what is for certain here is that Sidney Powell is not stating what the media says she's stating. The media says that Sidney Powell is claiming no one would believe what she's saying is true. That's not at all what she's saying. They're misrepresenting her words here. And that is, of course, par for the course in this election. As we know from the Time magazine article, everything about this election and how it is presented in the public, in the media space, has been controlled for well over a year. And again, that's not me saying it. That's Time magazine interviewing the people who orchestrated it. So it should come as no shock that the entire media is representing Sidney Powell in the same way here. And that is not what her lawyers are saying, and that's not what she's actually doing. This is a valid legal defense for defamation claims, is to say these are not statements of fact, because that's a legal issue. They must be statements of fact for them to be actionable. She says they're not statements of fact. In the context, these are my opinions, my personal opinions that I'm bringing as part of a court case, and these opinions need to be tested in court. And everybody listening to me, reading these opinions, hearing these opinions, would know that they are untested right now and need to go before the court. And indeed, Sidney Powell and others have made a big deal about how the courts refuse to quote unquote test their theories and their allegations. So that's going to be the defense. Like I said, I don't think she's going to win at this motion to dismiss stage, and we'll have to follow the lawsuit through to its conclusion. But it certainly is interesting, and it is always lovely to see the media completely misrepresent what's going on. Either they know what they're doing and they're doing it maliciously, or they literally just don't know how to report on legal issues. Probably both. Probably both. I don't know. What do you guys think? Drop a comment down below. Tell me what's going on. Do you think Sidney's going to win, lose? Do you think the media is being a bunch of jerks, or do you think the media is right on this one? Let me know. We'll talk soon. Have a good day. Peace. Peace.